So in this video, I want to talk about how California is attempting to defy and circumvent the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. But real quick before we jump into this video, if you think the state of California needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main sponsors of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, in this video, I want to talk about how California is already moving to defy and circumvent the Supreme Court's ruling on concealed carry. If you aren't aware or you've been completely just out of the loop, last week the Supreme Court issued a 6-3 decision authored by Justice Thomas, which did two very important things. In that decision, the Supreme Court struck down all May issue licensing permit schemes, but also reaffirmed the constitutional test that a government must meet to uphold their restrictions on firearms. In the decision, Thomas and the majority directly rejected the two-step approach and instead reaffirmed text as informed by history and tradition as the appropriate constitutional analysis when looking at Second Amendment violations. The fact that the Supreme Court rejected the two-step approach bodes very bad for states like California, who have exclusively relied on that approach to uphold their Second Amendment violations. More directly, California was impacted by the decision because the court stated that California is among the 6 states which uses a subjective proper cause standard when they issue permits. The court found that states that use that type of standard are violating an individual's right to carry a firearm outside of their home out in public for self-defense, and therefore they must stop. Soon after the announcement of that decision by the Supreme Court, Gavin Newsom and the California Attorney General Rob Bonta came out pretty much just berating the Supreme Court and promised legislation in California that would circumvent the decision however they could. Well, a couple days ago, the California Attorney General's office also released a legal alert on the whole CCW permitting process in the state of California. The letter states, on June 23, 2022, the U.S. Supreme Court issued a decision in New York State Rifle and Pistol Association v. Bruen. In that case, the court concluded that the state of New York's requirement that proper cause be demonstrated in order to obtain a permit to concealed carry a weapon in most public places violated the Second and 14th Amendments. Although Bruen concerns a New York law, the Bruen majority specifically identifies California as one of 6 states that has an analog to New York's proper cause standard. Accordingly, it is the Attorney General's view that the court's decision renders California's good cause standard to secure a permit to carry a concealed weapon in most public places unconstitutional. Permitting agencies may no longer require a demonstration of good cause in order to obtain a concealed carry permit. However, local officials can and should continue to apply and enforce all other aspects of California's law with respect to issuing public carry licenses. In particular, the requirement that a public carry license applicant provide proof of good moral character remains constitutional. So I want to stop here and break this down a little bit. So first and foremost, the Attorney General has directed all issuing agencies to pull the good cause requirement. That is a major deal for people who have lived in restrictive areas like San Francisco and LA, where it's been next to impossible to get a permit to carry concealed. Now, I know some people have been asking me if I think it's a good idea for you to start applying for these permits if maybe you live in one of these restrictive areas that maybe is now open. My answer to that is yes, because what is likely going to happen from here is that we will see an influx of CCW permits, especially in those areas like LA and San Francisco, where it's been next to impossible. And it's a good idea for you to get in line right now. Also keep in mind that these law enforcement agencies in those areas are not used to the processing of applications because they just never issued permits before. And I would expect some sort of delay in those areas because there's going to be a ton of people applying and they've never done that process before. And also I think that some of those areas are just going to simply drag their feet anyways. Now, another thing you just saw mentioned in the letter was that local officials must continue to apply and enforce all other aspects of the CCW licensing requirements. So you will still be required to take your training course, submit to fingerprinting and background checks. You will have to pay fees. And also, where California plans to defy the Supreme Court, they plan to push agencies for more stringent moral character requirements and also for psychological exams. This is where California, among other plans that they're putting in place, intends to circumvent that ruling by the Supreme Court. The letter states, accordingly, in assessing whether an applicant has established good moral character, issuing authorities should recognize that Bruen does not eliminate the duty or authority of local officials to protect the communities that they know best by ensuring that licenses are only issued to individuals who, by virtue of their character and temperament, can be entrusted to abide by the law and otherwise ensure the safety of themselves and others. The investigation into whether an applicant satisfies the good moral character requirement should go beyond the determination of whether any firearms prohibiting categories apply, such as mental health prohibition or prior felony convictions. Those categories, which may be found to apply during the DOJ conducted background check, simply determine whether an applicant is even eligible to own or possess firearms under state and federal law. When it comes to evaluating an applicant's moral character, however, the issue is not whether the applicant meets the minimum qualifications to own or possess firearms under other statutory criteria. Good moral character is a distinct question that requires an independent determination. As a starting point for the purposes of investigating an applicant's moral character, many issuing authorities require personal references and/or reference letters. Investigators may personally interview applicants and use the opportunity to gain further insight into the applicant's character, and they may search publicly available information, including social media accounts, in assessing the applicant's character. So what does that all mean? Well, the state of California thinks they can get cute with the Supreme Court's ruling. They think just because the decision mentioned proper cause as invalid, all they have to do is remove that and shift that subjective good cause standard over to a category of good moral character. The Supreme Court's decision in Bruen was not just focused on good cause or proper cause. Instead, the court stated a state cannot use a subjective standard which has no basis in historical precedent to restrict access to carry. That is exactly what the state of California will try to still do with the good moral character requirement. It was also hilarious to see that in this letter they're citing to Justice Kavanaugh as a basis for why they can do this, when actually in the decision he stated, going forward, therefore, the 43 states that employ objective shall issue licensing regimes for carrying handguns for self-defense may continue to do so. Likewise, the 6 states, including New York, potentially affected by today's decision, may continue to require licenses for carrying handguns for self-defense so long as those states employ objective licensing requirements like those used by the 43 shall issue states. California's good character requirement that they're now trying to deploy is not objective in nature. Instead, it's purely subjective. An issuing agency will now get to look at your background, they will get to look at your social media, they will interview you, and then subjectively determine if you have good character. This is drastically different from the other 43 states and how they do it, where if you simply pass a background check, if you're not a prohibited person, then you can get a permit. California is not doing that at all. They are simply shifting the subjective good cause standard over to a good character standard, and that is a direct violation of the Supreme Court's ruling. Another tactic that California might try is they might try to have super long wait times or heavy fees for the licensing, and all those would also be struck down because the Supreme Court said in Bruen that you can't create a shall issue scheme in name, but make it so restrictive that no one gets a permit. Also in the letter, the Attorney General mentioned sensitive places and that the state can still restrict carry in sensitive places. That may be true for some historically recognized locations like those mentioned by the Supreme Court. That may include like places like the federal buildings, courthouses, voting locations, etc. But these sensitive places must be rooted in a history and tradition of being a sensitive place. So the takeaway from California's letter is that they have ordered agencies to remove the good cause standard. That does open the door for more permits to be issued in areas of California that prior you could just simply never get a CCW permit. However, the state's new plan, as outlined in the letter, is to create a subjective good moral character requirement that they will likely weaponize to deny permits. If that is the case, we will no doubt see the state of California be sued because of that standard. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, the station with Built Bar Arms Scholars and the station with Maintain Bar Arms Scholars.